Hello everyone, and thank you for joining me for November 2018 My PIP Monthly. This is Javon David. I'm a partner at Secrest Wardle. I'll be joined today by my colleague Erin Ferguson, who will talk to you a bit about motorcycles and PIP law in Michigan. So this month we've got a couple topics on the agenda. We are going to discuss Court of Appeals decisions that came down in November and how they apply to your claim handling. We've got 3 cases to discuss: MIC General Insurance versus Michigan Municipal Risk Management. The next case is Sappington versus State Farm. And then finally we'll go through Citizens versus Schulte and Auto Club. And as I mentioned, Erin Ferguson will talk about trending topics in no-fault litigation, particularly motorcyclists and PIP priority. So let's begin. The first case to discuss is the MIC General Insurance Company versus Michigan Municipal Risk Management Authority. That case involved government transportation providers and whether or not they are exempt from liability to passengers for PIP benefits if they are transporting individuals in buses. So in MIC, which can get a bit confusing with all the acronyms here, but the claimant was a passenger on a medical transportation vehicle owned and operated by Mecosta County Commission on Aging and insured by defendant MMRMA, which is a group of self-insurance created by an intergovernmental contract. The claimant, after the accident, submitted a claim for first-party benefits to her no-fault insurance, which was MIC, the plaintiff. The plaintiff, MIC, made payments in excess of $200,000 and then brought suit against defendant for recovery of those benefits because it alleged that defendant was higher in the order of priority under MCL 500.3114 subsection 2. It was defendant's position that that subsection did not apply to them and that it was exempt under the statute because it was transporting an individual in a vehicle that did not apply to buses. So both parties moved for summary disposition. Ultimately, the trial court held there was no question that the MCCOA was operating a vehicle in the business of transporting passengers within the meaning of the No Fault Act. However, the trial court agreed MCCOA was exempt under subsection 2C of 3114 because it was transporting passengers on a bus operating under a government-sponsored transportation program. The trial court applied the dictionary definition of the word bus in support of the decision to grant MMRMA's motion for summary disposition, holding that MMRMA was not in the order of priority. On appeal, the Court of Appeals examined the issue of whether 31142 applied and whether the exemptions under the subsection would apply to the MCCOA. To first determine if MCCOA's vehicle was covered by the No Fault Act, subsection 2, the court ultimately had to decide whether the statute only applied to for-profit businesses or if it covered non-profit transportation vehicles. MMRMA argued the statute only applied to for-profit transportation companies and not nonprofits. The court did an extensive examination of the facts of the case and ultimately looked at the primary purpose and incidental nature test outlined in the case of Farmers Insurance versus AAA to determine if the vehicle was in fact being operated in the business of transporting passengers. In Farmers, there was no requirement that only for-profit transportation providers afford first-party benefit to passengers. In addition, MMRMA did not contest the primary purpose of the vehicle was to transport passengers. There was significant discussion about whether the transportation service was primary or incidental to the Mecosta County government, and ultimately the court found that the transportation service was a primary component of the MCCOA. The court next dealt with whether MCCOA's vehicle was exempt under either 2C or 2D, and under MCL 31142C, buses operating under a government-sponsored transportation program are exempt from providing first-party no-fault coverage to passengers. The court agreed with the trial court and held that MCCOA's vehicle was operating under a government-sponsored transportation program at the time of the loss. Once that determination was made, the only remaining question was whether the MCCOA's vehicle was a bus, as only buses are exempt under subsection 2C and D. Again, the court looked to the dictionary definition of bus because there was no definition contained in the No Fault Act. And ultimately, the Court of Appeals determined that a bus is a long motor vehicle for carrying passengers. In examining the vehicle owned by the MCCOA, the court noted that it was an FE350 van or wagon customized to allow transportation for patients in wheelchairs. Photographs depicted the vehicle as a cargo van with a raised roof, a box-like shape with rear and side doors, and side panels with windows. The vehicle could seat about 9 or 10 passengers, which of course is very different than a bus. And the court then said, by contrast, a bus typically has a rectangular cabin, a driver cab separated from the passenger compartment, a side entrance with articulated doors, and stairs to enter from the door to the cabin area. In addition, a bus usually has a center aisle, dual rear wheels, and can create more room for more passengers. None of these characteristics were present in the MCCOA vehicle, so the court was not persuaded by MMRMA's arguments about the legislative intent or analysis of MCL 500.3114, as the clear and unambiguous text stated the statute applied only to buses. The court concluded the MCCOA vehicle was more like a van than a bus, and that MMRMA was not exempt under 3114 2C or 2D. So, all of that aside, the rule that comes from that case is that government transportation providers whose primary purpose is to transport passengers are only exempt from liability to passengers for PIP benefits if they are transporting individuals in buses. And the vehicle has to meet the definition of a bus as defined by the Court of Appeals here, which ultimately just looked to a dictionary definition of what a bus contains. So when going through these kinds of claims, you're going to want to make sure that the vehicle that you're insuring or addressing does meet the bus definition in determining priority for PIP benefits. So the next case that we've got for today is Sappington versus State Farm. And in that case, the Court of Appeals addressed a priority dispute between a commercial and personal insurer in the context of an employee-furnished vehicle. And in that suit, the plaintiff filed an action seeking PIP benefits for injuries arising out of a single commercial truck accident. The plaintiff was sleeping in the back of the truck when the vehicle went off the road and crashed. At issue was a priority dispute between plaintiff's personal insurer, State Farm, and the commercial insurer of the truck, Cherokee. Specifically, the two insurers disagreed over the applicability of 3114 subsection 3, which is also known as the employer-furnished vehicle super priority. This provision provides that an employee, his or her spouse, or a relative of either domiciled in the same household, who suffers accidental bodily injury while an occupant of a motor vehicle owned by or registered by the employer, shall receive personal protection insurance benefits to which the employee is entitled from the insurer of the furnished vehicle. Both insurers filed competing motions for summary disposition. State Farm, represented at the trial court level by one of our own attorneys, Olga Casina, argued that plaintiff was the self-employed owner-operator of the commercial truck and was therefore entitled to benefits from the insurer of the furnished vehicle. The trial court, however, agreed with Cherokee, finding plaintiff was an independent contractor and not an employee. Therefore, his personal insurer was highest in order of priority. The parties then proceeded to the Court of Appeals. Now, when examining this case, of course, an individual first turns to his or her own insurer when seeking personal protection benefits. However, there's a limited number of exceptions. One such exception is the employer-furnished vehicle super priority, which is found in MCL 500.3114 subsection 3. The applicability of the statute depends on two things. Number one, the ownership of the vehicle, and number two, the individual's employment status. Addressing the first prong, in this particular case, The Court of Appeals noted that the commercial truck was registered to an entity called Truck Forward, an Ohio-based company. Plaintiff leased the truck from Truck Forward, rendering him an owner of the vehicle. Plaintiff had use of the vehicle for more than 30 days, which again deemed him an owner of the commercial truck. However, the plaintiff then leased that truck to TST, who paid him to drive the truck hauling TST's cargo. So, pursuant to the lease agreement, TST was also an owner of the subject vehicle. It was TST that obtained the commercial policy of insurance on the truck through Cherokee. So, the analysis next shifts to plaintiff's employment status. Was plaintiff an employee? Cherokee argued that plaintiff was considered an independent contractor of TST, and therefore he could never be considered an employee of anyone under the No-Fault Act. The Court of Appeals disagreed, citing to the case of Salina versus Lake States, which held that a person can simultaneously be both employed as an employee and an employer under the No-Fault Act. Specifically, in the self-employment context, someone who is self-employed is an employee of himself. The Michigan Court of Appeals further stated that if a person is self-employed, that person is necessarily both an employer and an employee for purposes of MCL 500.3114 subsection 3. Therefore, if plaintiff is an independent contractor, then he is necessarily an employee of himself. At the trial court level, Cherokee relied on the case of Adanilak, which I think I'm saying wrong, versus Harco, which is a 2015 Court of Appeals published decision, which it argued stood for the proposition that an independent contractor is not considered an employee for purposes of the No-Fault Act. The Court of Appeals noted that there was significant distinction between that case and the facts of this particular case. In the Adanilak case, the injured party did not own the vehicle in which he was injured, rendering his self-employment status irrelevant. In the facts at hand, plaintiff owned the vehicle in which he was injured. Even if he was an independent contractor of TST, he was ultimately an employee of himself. So, in reversing the trial court's decision and finding in our favor, the Court of Appeals reasoned that plaintiff was both an independent contractor of TST and an employee of himself, or he was an employee of TST. Either way, he was an employee of an owner of the truck. Since Cherokee, and not his personal insurer State Farm, insured the truck, Cherokee was the priority insurer as a matter of law. Now, the final case that we have on our agenda for today from the Court of Appeals this month is the case of Citizens Insurance Company versus Schulte and Auto Club. Now, in that case, it dealt with the cancellation of no-fault policies and having particular language in your cancellation notice to an insured, which is very key to whether or not you're going to be successful in actually upholding the cancellation if you're ever challenged on it in litigation. So in the Citizens case, the claimant was involved in a motor vehicle accident on January 9th, 2012, while driving a vehicle and owned by her father, Jerry Schulte. Mr. Schulte renewed his policy with ACIA for 1 calendar year in May 2011 and paid his premiums on an installment plan. The claimant was involved in an accident and had her claim denied by ACIA, who asserted that Mr. Schulte's policy had been canceled for failure to pay premium insurance payments. ACIA alleged that Mr. Schulte's policy cancellation was effective January 3rd, 2012, 6 days before this accident. The claimant did not have any other insurance coverage and ultimately sought coverage through the assigned claims plan. Thereafter, the Citizens was assigned to the claim and paid her PIP benefits. They thereafter filed suit against both Mr. Schulte and ACIA for reimbursement of the no-fault benefits paid. Mr. Schulte then filed suit against ICA for breach of insurance contract. Now, the key issue in this, procedurally drawn out case had to do with the language of the cancellation. ACIA sent a document entitled Auto Insurance Cancellation Notice and dated December 14th, 2011. The letter did not include cautionary language mandated by the statute or provision 500.3020 subsection 6. ACIA sent a second cancellation of policy to Mr. Schulte on January 17, 2012, which is 8 days after the motor vehicle accident. The second cancellation notice did contain the requisite language of the No Fault Act, but it was also after the accident. So, after several motions for summary dispositions were heard, the trial court ultimately determined that ACIA did not timely mail the proper notice of cancellation, and they granted Mr. Schulte's motion for summary disposition. The case ended up in the Court of Appeals, and ACIA argued that the trial court erred when denying its motion for summary disposition and granting Mr. Schulte's summary disposition. The question at issue before the Court of Appeals was whether the trial court erred when it denied ACIA's motion and instead granted the case in Mr. Schulte's favor, and further, whether the court incorrectly awarded him attorney fees and interest. Now, there was no question of fact that the one-page document sent to Mr. Schulte before the accident did not include the cautionary language mandated by the No Fault Act, and therefore rendered the cancellation notice ineffective. As a result, Mr. Schulte remained insured with ACIA on the date of the accident, so the Court of Appeals upheld the ruling in favor of Mr. Schulte. Now, it's important to review this case and have it serve as a reminder to include the proper language when you're sending out claims for denial, and to take the proper processes if you're trying to either rescind a policy or cancel a policy. Rescission has its own things that you got to do, return the premiums, put them on notice, and all of that needs to be done so that your rescission, or in this case the cancellation, can be deemed valid if and when the case goes into litigation and ultimately reaches the Court of Appeals. So, again, look at the statute 500.3020 and include cautionary language, which is there to protect insureds from improper insurance policy cancellations. And, the statute says that a letter cancellation sent to an insured by an insurer shall be accompanied by a statement that the insured shall not operate or permit the operation of the vehicle to which notice of cancellation is applicable, or operate any other vehicle unless the vehicle is insured as required by law. That's the key language that is going to need to be included in your cancellation letter for you to be able to uphold a cancellation.
Attention, please.
Okay, so that's all that we've got for the Court of Appeals update for this month, those 3 cases. If you need more information on that, just feel free to contact me. And now Erin Ferguson from our firm is going to talk to you a bit about trending topics in PIP litigation, and this month's topic is motorcyclists and PIP priority.
Hi, Javon.
Hi, Erin. Thank you for joining us.
Thank you for having me. Well, in discussing motorcyclists and PIP priority, it is important to remember that a motorcycle is specifically excluded from the definition of a motor vehicle under the statute, MCL 500-3101. So as a result, there are some nuanced differences in PIP priority when compared to that of an automobile. Now, specifically, the statute provides that the owner of a registered of a motor vehicle is required to be registered in this state for a security of payment of benefits under personal protection insurance. And the statute defines a motorcycle as having a seat or a saddle and operating on no more than 3 wheels, and it defines a moped and off-road vehicle as vehicles that are not a motorcycle. So you see here there's a specific difference between the way the statute defines a motor vehicle and a motorcycle. And additionally, Section 3103 discusses the requirements for insurance coverage for motorcycles in Michigan. And so the owner or registrant of a motorcycle has to provide security against loss from liability for property damage, bodily injury, or death suffered by a person arising out of the ownership, maintenance, or use of that motorcycle. Now remember, a motorcycle is excluded from the definition of a motor vehicle in Section 3101. So this is important when looking at PIP priority, because if a motorcyclist is involved in an accident with a motor vehicle, the cyclist is entitled to receive PIP benefits from the carrier that provides coverage to that motor vehicle. And that motorcyclist can receive PIP benefits as if they were in the motor vehicle that was involved in the collision. The exception, however, is if the motorcycle operator does not have the requisite coverage that is required by Section 3103. And if a motorcyclist is involved in an accident with another motorcycle, or if the cyclist has to put their bike down or has a fall, then that cyclist has to turn to the coverage they purchased from their own carrier, if they have purchased any. Because again, if the motorcycle operator does not have the coverage required by 3103, they may not receive PIP benefits. Now, specifically, MCL 500-3113 governs when a person is precluded from receiving first-party benefits, and this is where we get this exact language from. A person is not entitled to be paid personal protection insurance benefits for accidental bodily injury if at the time of the accident any of the following circumstances existed. And the person in that instance would be the person was the owner or registrant of a motor vehicle or motorcycle involved in the accident with respect to which the security required by Section 3101 or 3103 was not in effect. So the bottom line here is, when looking at motorcyclists and PIP priority, if the operator of the motorcycle does not have the requisite bodily injury coverage, they are not entitled to PIP benefits.
So I guess from the adjuster's perspective, what do you recommend?
So as an adjuster, when you first receive a claim where a motorcyclist is alleging their old PIP benefits, it's important to look at the PIP priority and not to jump to, trying to determine other damages. Look at whether or not that person was the owner or registrant of the motorcycle, and if so, whether or not they have the coverage that 3101 and 3103 requires.
Okay. Erin Ferguson actually did a complete webinar on this particular issue that goes into more detail about what you should be looking for, what exactly the definition of a motorcycle is under the No Fault Act and how it applies. So if you'd like to sign up for that particular webinar, you can visit our website, or you can contact Erin Ferguson directly, and her information is located on the last slide there. So we thank you for joining us for this month's My PIP Monthly, and we look forward to you tuning in next month. Thank you.
Thank you.